All right. In general, this is 3403. In general, if a note of issue is filed without a request for a preference, any other party entitled to a preference should make his motion for a preference within 10 days after the filing of the note of issue. 4111. A court has directed a jury to find a special verdict. In such cases, the jury must determine the facts only. The Chief Judge for the Court of Appeals is authorized to promulgate rules for the arbitration of claims of a sum of money. This is in 3405. Okay, and this is a list of 5 things that are true regarding that. Such rules may authorize the use of JHOs as arbitrators. The monetary limit shall be $6,000 outside New York City exclusive of interest. The monetary limit shall be $10,000 within New York City exclusive of interest. A judgment may be entered on an arbitration award, and such rules must permit a jury trial to novo on demand of any party following the determination of the arbitrators and may require the demander to pay the cost of arbitration. If JHO is appointed, only one arbitrator is appointed. If it's not JHOs, the court could appoint either 1 or 3. 3211. An objection that the summons and complaint or notice of petition and petition or whatever was not properly served is waived if, having raised such objection in his pleading, the objecting party does not move for judgment on that ground within 60 days after service of his pleading, unless the court extends the time upon the ground of undue hardship. This stuff in 3211 about the moving for judgment does not apply to subdivisions 1 and 2 of section 711 of the Real Property Actions and Proceedings Law. 3212. Any party may move for summary judgment in any action after issue is joined. 3212. A court may set a date after which no motion for summary judgment may be made, such date being no earlier than 30 days after the filing of the note of issue. If no such date is set by court, such motion shall be made no later than 120 days after the filing of the note of issue, except by leave of court upon good cause shown. 3215. If plaintiff fails to take proceeding for the entry of judgment within 1 year after a default, the court shall not enter judgment, but shall dismiss the complaint as abandoned without costs, sua sponte, or on motion. And that's 1 year. And this is talking about the plaintiff failing to take entry on the default judgment. And then this other thing is the objecting party has to move for the grounds on not proper service 60 days after service of his pleading, where he objects to it. Any action except a matrimonial action may be commenced by filing with the court a submission of the controversy acknowledged by all parties in the form required to entitle a deed to be recorded. 3217. Any party asserting a claim may discontinue it without court order by serving upon all parties a notice of discontinuance at any time before a response of pleading is required, within 20 days after service of the pleading, asserting the claim and filing the notice with proof of service upon the clerk. So this is about a discontinuance, and they can discontinue it without court order by serving upon all parties a notice of discontinuance at any time before the response of pleading is required, or within 20 days after service of the pleading asserting the claim and filing notice with proof of service upon the clerk. Okay. 3219. At any time not later than 10 days before trial, any party against whom a cause of action based upon a contract express or implied and against whom a separate judgment may be taken without court order, deposit for safekeeping an amount of money with the clerk deemed by him to be sufficient to satisfy the plaintiff's claim, and serve upon the claimant a written tender of payment to satisfy the claim. Okay, this is about the action on submitted facts. 3222. An order of attachment or a preliminary injunction shall not be granted. The controversy shall be determined on the case alone. Let me start over with this. Okay, this is about the action of submitted facts on 3222. And I'm going to say 5 things here to remember about them. 1. An order of attachment or preliminary injunction shall not be granted. 2. Controversy shall be determined on case alone. 3. If action is made to Supreme Court, it shall be heard and determined either by the court or by the appellate division or with his consent by a specified judge or referee as parties may stipulate. 4. Judge or referee may find facts by inference from the facts stipulated. And 5. If the statement of facts is not sufficient to enable court to enter judgment, the court shall allow the filing of an additional statement, or it may dismiss the case. So it could do either one of those things. In every med, dental, or podiatric malpractice action, the court shall hold a mandatory settlement conference within 45 days after filing of the note of issue and certificate of readiness. 3408. This is plaintiff shall file the notice of discontinuance and vacatur of lis pendens within 90 days from when such agreement or loan modification is fully executed. The court may not grant summary judgment in favor of a non-moving party in an action for divorce, annulment, and I think that was it. 3215 F. On any application by default, the moving party shall file proof of service of summons and complaint or summons of a notice, as well as proof of the facts constituting the claim, the default, and the amount due by affidavit. When jurisdiction is based upon an attachment of property, the following is true regarding the affidavit. 1. State that an order of attachment granted in the action has been levied upon the property of the defendant. 2. Describe the property that has been levied upon. 3. State the value of the property that has been levied upon. 4. The affidavit must be made by the party, unless a verified complaint has been filed or moving party is the state, in which case it may be made by the appropriate attorney. And this is about a default judgment. They have to file this proof of service and an affidavit. The facts constituting the claim, the default, and the amount due by affidavit. And when jurisdiction is based upon an attachment of property, this stuff has to be in the affidavit. (3216) Before a court can dump an action for want of prosecution, you have to serve a written demand to resume prosecution of the action within 90 days of the receipt of such notice. I think that thing's got to be sent by certified or registered mail. 214 sub 7. In general, an action to annul a marriage on ground of fraud must be commenced within 3 years. But if the spouse is not the one that discovered the fraud, it's measured from when the spouse discovered the fraud anyway. 214 sub 1. In general, actions against the sheriff, constable, or other officer for the non-payment of money collected on execution must be commenced within 3 years. 3218. At any time within 3 years after affidavit confessing judgment, so this is about a judgment of confession, anytime within 3 years after it's executed, it can be filed with the clerk of the county where defendant stated in his affidavit that he resided when it was executed, or if defendant was a non-resident, with the county clerk designated in the affidavit. Thereupon, the clerk shall enter a judgment in the Supreme Court for the sum confessed. He shall tax costs to the amount of $15, disbursements taxable in an action, and no judgment by confession may be entered after the death of someone. And that makes sense, because then they wouldn't be there to dispute it. 3105. Basically, when a party is in default for failure to appear, he shall not be entitled to notices pertaining to discovery. 4101. The following actions in which there is an issue of fact shall be tried by a jury unless a jury trial is waived or a reference is directed. 1. Demands for money only. 2. Ejectment. 3. Nuisance. 4. Dower. waste. 5, action for determination for a claim on real property. Dam discovery. Generally, there shall be a full disclosure of all matter, material and necessary, in the prosecution or defense of an action, regardless of the burden of proof. Okay. Full disclosure has to be made by an officer, director, member, agent, or employee of a party. A person who possessed a cause of action or defense asserted in the action. 3, a person about to depart the state or without the state, or residing more than 100 miles from the place of trial. 4, a person so sick or infirm as to afford reasonable grounds to believe he will be dead before the trial, or unable to attend the trial. 5, a person authorized to practice medicine, dentistry, or podiatry, who has provided care to the party demanding disclosure, who has been retained by such party as an expert witness. 4, any other person, upon notice stating the circumstances or reasons such disclosure is sought or required. And 7, a party to the action. 3101. In what type of actions may a party omit the name of his experts? And those are medical, dental, and podiatric only. A party may obtain a copy of his own statement. If he, I think if he doesn't it's like a deposition. He's got to return it within 60 days, otherwise they could use it anyway. Alright, here we have a list of the 7 disclosure devices that is in 3102. Depositions upon oral questions, that's 1. 2, without the state, depositions upon written questions. 3, interrogatories. 4, demands for addresses. 5, discovery and inspection of documents or property. 6, physical and mental examinations of persons. 7, requests for admission. Okay, the next thing, this is in 3102, 3103, and 3106, and it's all about disclosure. Damn disclosure. 1, in an action where the state is properly a party, disclosure by the state shall be available as if the state were a private person. 2, the court may at any time, sua sponte or on motion, make a protective order. 3, disclosure to aid in arbitration must be obtained only by court order prior to commencement of an action. 4, service of a motion for a protective order shall suspend disclosure of the particular matter in dispute. 5, the deposition of a person confined under a legal process may only be taken by leave of court. Powers of referee supervising disclosure. Motions referred to person supervising disclosure. Such referee shall have all the powers of the court except 1, power to relieve himself of his duties. 2, a power to appoint a successor. And 3, the power to adjudge a person guilty of contempt. 3107. The party desiring to seek deposition of any person by oral examination shall give each party 20 days' notice unless court orders otherwise. 3108. A commission or letters rogatory may be issued where necessary or convenient for the taking of a deposition outside the state. Errors or irregularities in the notice for taking the deposition are waived unless 3 days before the time written objection is served upon the party given the notice. That's 60 days. About the deposition has to be signed, otherwise they can use it anyway. Okay, when a party submits an out-of-state subpoena to county clerk, the clerk, in accordance with that court's procedure, and subject to the provisions of Article 23, shall promptly issue a subpoena for service upon the person to whom the out-of-state subpoena is directed. Certified business records 30 days before trial, whereupon the other party must object at least 10 days before trial. Such objection may be started in any instance. 3122A1. Objections to disclosure, inspection, or examination must be made within 20 days after service of a notice or subpoena to seek them.